Yeah. Oh, well. Yeah. All right. Please come on. Hi, good morning. We're going to start with the call on the docket.
Terry Lynn Gang versus Justin Cullen Gang.
Well, Your Honor, Kendall White for Mr. Gang. There was an agreed order of substitution of counsel. I don't think that it got filed somehow. But I'm standing in for Mr. Gang. I'll reach out to Mrs. Kokenhauer's assistant. She's the one who had me sign it. I gave it to them to file, and then I didn't follow up. So that's all.
So this is only here on a motion to withdraw?
Yes, Your Honor. And there's an agreed order of substitution of counsel.
All right.
It's
So
been
there's an
taken.
agreed order of substitution, the motion withdraw.
It's not, it hasn't been filed, but there is an agreed order of substitution of counsel out there somewhere. I could get it filed. I could probably go print it off somewhere with my email. I will warn the court, I am bouncing back and forth between the courthouses right now. I got bagged into helping the general sessions court with some of their bond docket stuff. And but as far as just a motion of substitute counsel, we've exchanged counsels. I've got the file. I just thought it was filed and I didn't follow up. That's on me.
That's fine. Well, the only, as I said, the only reason it was here today was because it was a motion to withdraw, but if there's an order of substitution coming, that'll take care of it. So,
Thank you, Your Honor.
all right, thank you.
Your Honor, that concludes my business. May I be relieved?
You may.
Thank you, Your Honor.
The matter of Huntley Cassidy Proctor.
Good morning. Are you Huntley Cassidy Proctor?
Yes, sir.
Ms. Proctor, I need you to raise your right hand. Let's place you under oath.
You solemnly swear or affirm the testimony you're about to give us the truth, whole truth, nothing but the truth, so help you God.
You have filed a petition to change your name, and I'm required by law to make sure that you're not doing this for some illegal purpose. Are you changing your name in order to avoid criminal prosecution for all of the crimes that you may have committed as an individual?
Your Honor.
Are you asking to change your name to avoid your just debts or creditors and all the debts that you've run up in your long life?
Your Honor.
All right. So you're just changing this to your stepdad's last name based on your relationship with him. Is that correct? Now you're 19?
Yes, Your Honor.
All right. So you have every right to do that, and you have submitted an order for the change of your name, and I will be happy to sign your order. So. Believe it or not, there are people who will want to change their name for those purposes, and that's the reason I'm required to ask. So somebody that I had a guy in another county who filed a petition, a name change, and he was doing it from the jail in Dickson County. So and he wanted to change his name, and I said, "So you have pending all sorts of sexual offenses that he was going to be waiting to stand trial on." I said, "Why would I change your name to allow that to happen?" He didn't have a good answer, but he really wanted his name changed. So you can imagine why. All right. Thank you. Your name has been changed.
Thank you.
You can get a copy of it a little later in the day downstairs, but we have to transmit it down there first. Okay. All right.
The matter of Caleb Levi Akers.
Judge, we submitted the motion to access funds. Caleb is going on vacation and guardian would like to request some funds to be.
This is your,
Pardon?
you have an armed guard now with you when you come up there? So,
My own personal bodyguard.
yeah, we all may need one at some point, so. Okay, and I've been advised that this is to allow him to purchase a ticket so he can go on a family cruise. Is that
Yes,
correct? I see no problem with that, and I will grant that request.
Thank you, Your
Have
Honor.
you
Thank you,
prepared an order?
I did, I submitted one.
Is it in? Oh, sorry.
Thank you.
What?
The estate of Peter Edwin Grusenbach.
Your Honor, second call at my clients.
We'll put it on the second call.
Oh, I'm sorry, it's here. It's expensation stuff down in 49.
All right. You stuck in that traffic jam where they were doing all the work?
By Cross
Yeah,
Creek.
what are they doing down there? I got something.
TDOT's gonna do some milling on the highway.
Great. I've got to go that way to go home too, so which means I'll be stuck in it going home. All right. You want to raise your right hand and let's place you under oath.
Do you solemnly swear or affirm the testimony you're about to give us the truth, whole truth, nothing but the truth, so help you God?
State your name for the record,
Laura Ann Brooks.
and you petitioned the court for the estate of Mr. Peter Grossenbach,
Yes.
and you know him, you know that to be his last will and testament,
Yes.
and do you have any reason to believe anybody's contesting this probate?
Not at all.
And then you know that Rebecca and Stephen are his only heirs at all?
Yes.
And you're asking the court today to appoint you as executor so you can see through the auction and sale of property.
They're Mr. Fate's last wishes.
All right. I will grant your request.
Lupe Daniel Duarte versus Heather Lynn Duarte.
Good morning, Your Honor.
Good morning.
Attorney Elizabeth Birch here for Mrs. Heather Duarte. This case was last set in front, this is a Judge Lockhart Ash case, Your Honor. And she heard our divorce, she's heard the order of protection. And she's set to hear all of these cumulative issues that have developed post-divorce on June the 5th. And that would be the motion for therapeutic, continued therapeutic visitation. We have a motion to suspend therapeutic visitation. There's some contempt issues.
Well, let me interrupt you and ask you a question because my review of the file is that there was a final decree of divorce that was entered in September of 2025.
Yes, Your Honor.
And that adopted a parenting, American Dissolution Agreement and a parenting plan. And under that parenting plan, the father was given 0 days with the child, and the mother was granted 365 days, and that he was to have parenting time to therapeutic visits with a minor child once per week for at least 1 hour. It could be longer based on the counselor's availability, the party's availability, his ability to pay child support, or to pay rather than the child's willingness. The mother would cooperate in bringing the child to therapeutic sessions each week. Now, there was also a reservation of the issue of the order of protection, if I understood correctly, and a motion by the father to modify, terminate the order of protection that was filed in September the 26th of 2025. But there is no motion or petition rather to modify that final decree.
There's not. Father filed right after our last court date on February 5th, wherein we were here for all these issues. Judge Lockhart Mash reset it to June because one of our witnesses couldn't be here and she wanted to hear the whole thing together. So she reset it for June, then Dad filed an emergency, I guess, motion to have therapeutic visitation. The issue we have is the therapeutic visitation company no longer wants to do
So
visitation.
my question is, what exactly is pending in the divorce action? Now, the order of protection, I understand, that's set before Judge Lockhart Mash. But is there any pleading that has been filed pursuant to the rules of civil procedure?
The only thing is Dad's emergency, motion for emergency, I don't really know. So that would
I
be the only
understand what
motion
he's
filed, but nothing to change this other than to just enforce it. We just don't have a provider who's willing to do the therapeutic visitation.
Objection, Your Honor. I have a provider that is willing to do it. I've forwarded it to Ms.
Well, what I'm doing, Mr. Duarte, is trying to determine what jurisdiction I have to hear anything. Because this matter is set by reservation of the order of protection to be heard by Judge Lockhart Mash, and that is to be heard in June. The final decree of divorce was granted in September of 2025. Under the rules of civil procedure, once that final decree goes down, you cannot modify the terms of that final decree and that parenting plan that was adopted, absent a petition to be filed pursuant to the rules of civil procedure that alleges that there has been a material change of circumstances that has occurred since the entry of that final decree of divorce. So, number one, no such pleading has been filed. You cannot file a simple motion and modify the final decree of divorce. It requires a pleading to be filed, which is a petition alleging a material change of circumstances or a complaint, either which initiates a new proceeding in this court. So what I want you to understand is that the only thing that's pending right now is that order of protection, which is set in June before Judge Lockhart Mash. Your motion for emergency hearing is asking me to do something that is going to affect what Judge Lockhart Mash has reserved personally to be heard by her in June. And I'm not inclined to do that. If you had filed a petition to modify the final decree and the parenting plan that was granted, then that would be a different matter. But right now, the only thing that is pending in this court is the order of protection, and that is set to be heard by a different judge.
Because I did first file to have the therapeutic visitation moved from one facility to another because they had dropped us due to no advancement in the reunification process and recommended that we find another facility to do therapeutic visitation. I found one, but because Clara Vita is listed in the permanent parenting plan, they cannot move forward with the visitation moving to the facility.
And what I'm explaining to you is that in order to accomplish that, you would have had to have filed a petition to modify or change the final decree and parenting plan, or to enforce those provisions of it. And what you have done is instead is file a motion, and your motion is ineffective because you only file a motion in a pending case. The only pending matter before the court is the order of protection, which has been consolidated with your divorce. And that part is set to be heard in June. Now, if you have visitation arrangements that you want to propose to Ms. Birch and her client, then you're welcome to do that. But what I want you to understand, I understand your frustration. And if I had something pending in front of me that I felt like I could effectively exercise my jurisdiction, I would do so. But in this case, the only thing pending is that order of protection, which Judge Lockhart Mash has set for hearing in front of her on that June date. And your request to modify that order of protection is something that I am not going to hear because it would be effectively second guessing what Judge Lockhart Mash is going to do in June. So my suggestion would be that you and Ms. Birch exchange this information that you have, and if she's willing to do that, that's fine. Otherwise, you're going to have to try to get in touch with Judge Lockhart Mash and see if she was willing to hear something on an emergency basis. I am not going to interject myself into the case that she is set to be heard, because the divorce case has nothing pending in it. The only thing that's pending is in the order of protection.
Yes,
Does
sir.
that make sense?
Yeah, that was, I didn't know that.
That's fine. And I'm trying to explain it to you in terms that you can understand, because I have to enforce the rules of civil procedure, and those rules are pretty specific about once a final decree goes down or a final order goes down, it is what we call res judicata, which is a fancy legal term meaning it's already been adjudicated. So the only kind of case in the world that you can reopen after the time for an appeal has taken place is a parenting plan and custody and child support issue. And that allows you to file a petition, but to do that, the rules require that you prove that you allege there's been a material change of circumstances. Now, contrary to that, this order of protection is still pending. And as a result, it is set for Judge Lockhart Nash to hear. And that's the reason that we don't interject ourselves and I don't take it away from here to here, because she's got it specially set in front of her. So what I'm going to suggest is that you talk with Ms. Birch, and then if that is ineffective, that you contact Judge Lockhart Nash's office, see if she will give you an expedited hearing on the motion. But I decline to hear it because she's already got it set.
Yes, Your Honor.
All right.
Thank you.
Thank you, Ms. Birch.
Your Honor, may I?
This is, if you have something you want to give to Ms. Birch and her client, you can do so, or at least tender it to them. And all right, we'll go from there. Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. No, what's next?
It's whatever. It's whatever. I'll be right back in here.
Timothy Ramos Smith Jr. versus Jessica Renee Powers.
All right, this is a complaint for divorce that was filed by Mr. Parks on your behalf. And there's a marital dissolution agreement that's been entered.
I think the question was, prior DCS case that accepted support and the parties are agreeing to a certain support. I think Judge Nash may have, make sure nothing will change. One of what I think will be on.
All right, both of you raise your right hand, let's place you on the oath.
You both solemnly swear or affirm the testimony you're about to give us the truth, whole truth, nothing but the truth, so help you God.
Yes.
Mr. Parks, there's an adjudication and disposition order. That was entered by the juvenile court. And that visitation order effectively grants custody of the minor child or children to the father and orders that the mother have visitation at the discretion of the father. And it also orders a $75 a week child support payment and $150 a week per child, I guess it is, for $150 a week payment of child support. Now, the exercise of the jurisdiction of the juvenile court of Stewart County granting custody of these children remains with that Stewart County juvenile court unless and until they relinquish the jurisdiction over that. So in other words, right now, all I have is a copy of an order that juvenile court has granted custody to the father So therefore, there would not be a need for a parenting plan because this order controls that situation. So all I can tell you is that in my opinion, I'm not going to sign your parenting plan order because the juvenile court of Stewart County has jurisdiction over your children. Your divorce can be granted, but it has to reserve the issue of the custody of the child to the juvenile court. Once juvenile court exercises jurisdiction over children on a dependent or neglect basis, that jurisdiction is exclusive, meaning that we cannot come in and take custody away from either one of you. We have to defer to the juvenile court. Once they've determined that there's no longer a need for their exclusive jurisdiction on a dependent and neglect case, then they can put an order down. The juvenile court, Judge Brigham, can put an order down that relinquishes jurisdiction back to the Chancery court. And that happens on a routine basis when things change. But right now, all I have is this order that says juvenile court's got custody, got jurisdiction, and they've granted you custody, and they put an order down about support. So I'm going to decline to sign your parenting plan because I don't think that I have jurisdiction over the children to do that. So I think you have to go back to juvenile court if you want to make any changes to anything and go from there.
Yes, Your Honor. Our main goal was just a legal separation. I want a divorce. We agree on everything.
Well, you need to do, if Mr. Parks is still representing you, then you can do what's called a legal separation, and you can do a separation agreement and put an order down that'll allow you to be separated for 2 years, you know, and operate under the terms of that marital dissolution agreement if you want to do that. But it would have to be an order for a legal separation rather than a final decree of divorce. So
I think they agree they want to be divorced. I think you just.
you do want to be divorced.
Yes, Your Honor.
All right. So has the decree been signed? Maybe I didn't look far enough.
We always got to be the difficult ones. I did.
We don't have a final decree, but obviously you can, let's see that file again, please. You've alleged the grounds of irreconcilable differences and you've executed a marital dissolution agreement. So that marital dissolution agreement was filed in February. So really all you need to do is just do a final decree of divorce. And in that final decree, you need to make reference to the fact that juvenile court has exercised jurisdiction over the children and that that jurisdiction remains the juvenile court. So, thank you. That can take care of it. Okay. Oh.
Thank you, Judge.
Matter of Aaliyah Ray Page.
Good morning. All right, this was a contested adoption and there's been an answer filed by the defendants in the case, but now their attorney has withdrawn and I see no one here. They have not appeared. So is this Aaliyah? Are you Aaliyah? How are you? How old are you, Aaliyah?
14.
All right. When you get to be my age, it's hard to tell how old young people are anymore. So look like you could be 18 for my yeah. All right. All those who are going to testify, raise your right hand and place you under oath. That includes you, Aaliyah. So.
Do you all solemnly swear or affirm the testimony you're about to give us the truth, whole truth, and nothing but the truth, so help you God?
All right, we'll let you go ahead and put on your proof now. Because of the fact that they have not appeared, we still have to have proof put on as to the grounds for the adoption, which would be first step is prove that there's been what we call a legal abandonment. And so I'll need evidence about that. And then once I make that ruling, then you can move to whether or not it's in the best interest for the adoption to take place. Okay? All right.
Very good, thank you, Judge. Sir, give us your name, please.
William Page,
And Mr. Page, you are married to who?
Michelle Page.
All right, is that her right there?
Yes,
All
sir.
right, you all filed this petition for adoption, is that right?
Yes, sir.
Was everything that you put in this petition, was it true, accurate, and correct?
Yes, sir.
All right, and what is your relationship to the defendant, Ray Anderson?
Ray Page is my brother.
Okay, and this is his daughter.
Yes, sir.
All right, and Crystal Page is the mother.
Yes, sir.
All right, and they were participating in this case. Their lawyer withdrew. You heard the judge's representation. Is that right? All right. And as far as their knowledge of this case here today, have you had some communications or heard about that Ray is aware of this case and
Yes.
is pending right now?
Yes.
He's aware of this court date here today?
Yes.
All right. Now, we filed this petition on January 18 of 2024. Does that sound right? All right. And if you look back in a 4-month window before that time, was there any visitation by the parents with the legal? Was there any support taken by them? How long has Aaliyah been in during your wife's care?
Since she was 5.
Okay, and she's 14 here today.
Yes, sir.
During that period of time, have biological parents ever offered any support to you all? And as far as visitation, has it been years since they've exercised visitation? And as far as their situation, have there been lots of criminal activity they've been involved in?
Yes, sir.
And have we obtained certified copies of all of a lot of their criminal activity?
Yes, sir.
Has that criminal activity taken place in Stewart County?
Stewart County, Montgomery County. I think Dickson's got a couple.
Okay. And
Paris.
with respect to, I'll start off with Ray, has that been meth charges, drug charges, things of that sort?
Yes.
And with respect to Crystal, what was?
Same thing.
And as far as your relationship with Aaliyah, do you believe it's best interest that this adoption continue forward? So that you and your wife serve as her primary caregiver and supporter and met all of her needs up to this point.
Yes, sir.
And as far as if the judge approves this adoption here today, you know it would be just as if she was born to the two of you.
Yes, sir.
You
She
all.
already has. She's ours. She's been ours anyway.
And legally, I guess today we're just kind of formalizing what you all been doing, but she would have the right to appear with you and you confer. If something got crossways, you and your wife, you guys might be talking about custody issues and child support issues. You understand all that. So, knowing all of those things, are you asking the court to approve this adoption?
Yes, sir.
Ma'am, you heard your husband's testimony here today.
Yes, sir.
Did you get it all right?
Yes, sir.
You believe everything he said?
Yes, sir.
When you ask a wife if her husband did everything right, it's a dangerous test territory.
And are you asking the court to approve this adoption today?
Yes, sir.
Would you affirm all the answers that your husband gave?
Yes.
You believe it's her best interest for this to happen?
Oh, yes.
And you're asking the court to approve this adoption here today?
Yes.
Aaliyah, you've got in front of you an affidavit that read, is that right? If you understand that what's happening here today, are you in favor of this adoption taking place here today? All right, you're asking the court to approve this adoption. All right, and this affidavit is basically your statement saying that you're okay with this happening. All right, and Judge, I've got it. I was going to have her sign it in your presence.
Aaliyah, you've been sworn in, so you're gonna be left-handed. Oh my goodness, my wife is left-handed, so that could be dangerous as well, so. I'm always told that left-handed people are smarter and more artistic and more creative and every other thing.
There's a lot of acting, Judge.
Juan, do you have anything to input on this?
Andrea Craig did all the legwork as GAL and I looked at her report. It's in the best interest.
Right.
And Judge, I don't have a decree here today because I didn't know who might show up, so I will submit one forthwith.
We don't always get to choose who our parents are, but I tell people all the time in these divorce cases that it takes more than simple biology to make a person a parent. It takes a willingness to assume those roles and to do the things that are in the best interest of their children. Often in divorce courts, you get people who are fighting with each other and they lose sight of the fact that what's really the most important thing is the best interest of the child or children that are involved in the case. So while your biological parents may not be the kind of parents that we would like them to be, and they may not have been involved in your life the way they should have been, that's not your fault. And the fact of the matter is that you've got two people who have stood in that same role and have assumed that role and are willing to be your parents. So whereas you've got two parents that are biologically your parents that don't apparently want to assume that role, you should not take that personally. You should look to the good that's in this situation, which is you have two people who love you and have been there for you all of these years and want to be there for you the rest of your life. So you have the opportunity to choose your parents, and are you willing to allow this adoption to take place? Then I'm happy to do that. I don't even have to change your last name, so which is often the times the case. But you're 14 and you understand, Mr. and Miss Page, that she's 14 now, so you already got a teenager on your hands. But you understand that in 2 years, she's going to be driving. And if she dents the car or does something like that, you can't bring her back to me and say, look, we made a terrible mistake in this situation. There's no refunds and no exchanges. So, Aaliyah, you are a lucky young lady to have this situation. I see a lot of tragic situations in this job, and it makes me very happy to be able to grant an adoption to two people who already are your parents. And all I'm doing is put the legal stamp on what the three of you already have created in your home. So congratulations. Congratulations to you, Mr. and Miss Page. That's a girl. So
Thank you, Judge.
you're going to submit a final decree. Is that
Yes,
correct?
Judge, I'll get that.
Right. Right there.
Thanks.
Thank you.
Is that okay to us?
Sure. They want to have a picture. Is that what you're asking? Why don't you come up here? You want to sit in the big chair?
She's in the criminal justice.
Oh.
She,
well,
She wants to be a forensic psychologist.
Here, you need to hold on to that. And give me the criminal justice. Yeah, come on over here if you want.
Right, that's perfect. Perfect. Thank you. Appreciate it.
What are you gonna do in your class? on Criminal justice.
We're learning about behaviors.
You're welcome to come back and observe court anytime you want. Okay. Oh. This is a better day than I thought it was gonna be when I started, and I got stuck in traffic on the way here at Bear Creek Springs or whatever that is. So that will conclude our docket of cases for today, and we've got two more people out there. Shut everything down because I've got to go back to Charlotte tomorrow and Thursday, back here Friday.